participating delegation Libya to make its oral statement before the court. I thus call upon Professor Ahmad Al-Gihani to take the floor. You have the floor, sir.
Mr. President, distinguished judges, good afternoon. It is my honor to be here before the court. It is the first time with my delegation in representing the Libyan submission to your court. First, let me say that the suffering of the Palestinian people, and in particular in Gaza Strip, nowadays are a clear evidence of consequences of the failure to address the Palestinian cause. The world is witnessing a large-scale and systematic heinous crimes being committed by the occupying power force, depriving the civilian population of food, water, and essential supplies. The aggression of the power of occupying power has not spared children, women, elderly people. There is no safe place for the people in Gaza to go to. The crimes amounted by Israel, the crime committed by Israel tantamount to the crime of genocide and other international crimes stated in the Article 5 and 6 and 7, 8 for the Rome Statute. This call on the international community as a whole and on organs of the United Nations to put an end to this tragedy and take concrete steps in order to enable the Palestinian people to realize their legitimate rights of self-determination. Therefore, we believe guidance from the court as the highest judicial organs in United Nations, and it is necessary and important. The presentation of the state of Libya before your court will address the following points. First, the jurisdiction of the court, then the illegality of the occupation of the Palestinian territory, then the consequences of the Israeli illegal actions, and then the summit. We can start from the first point, that the jurisdiction of the court. As you know, Mr. President, member of the court, that the Article 96, paragraph 1 of the United Nations Charter provides that the General Assembly or the Security Council may request the International Court of Justice to give an advisory opinion on any legal question. On the other side, the Article 65, paragraph 1 of the court's statute further stipulates that the court may give an advisory opinion on any legal question at the request of whatever body may be authorized by or in accordance with the Charter of the United Nations to make such request. These two provisions are, according to our view, sufficient to establish the competence of the General Assembly to request the advisory opinion from the court and the jurisdiction of the court to give the requested opinion. We go to the second point, the applicable law. The international humanitarian law. First, the international humanitarian law. It is, as you know, settled that 1949 Geneva Convention relative to the protection of civilian persons in times of war apply to the OPT, as noted by the court in the Wall opinion. In addition of that, the 1907 Hague Regulation have become a part of customary law and therefore apply to the OPT, despite the Israeli argument that the Fourth Geneva Convention does not apply to the OPT. The court found, as a matter of treaty law, that does indeed apply, as it would to say, and occupy territory to prevent an armed conflict arising between two or more high contracting parts. In 2001, the conference of high contracting parties reaffirmed the applicability of the Fourth Geneva Convention in the occupied Palestinian territory, including East Jerusalem, Quds, and called inter alia upon the occupying power to immediately refrain from committing grave breaches involving any of the acts and mentioned in the Article 147 of the Fourth Geneva Convention, such as killing, torture, deportation, depriving of the rights of fair and regular justice and trial, extensive destruction and appropriation of the property not justified by military necessity. Plus that is applied the international human rights law. A variety of international human rights treaties apply to the proceedings. Among the most important of these are the International Covenant of Civil and Public Rights, International Covenant on Economic, Social, and Cultural Rights, the International Convention on Elimination of All Forms of Racial and Discrimination, the International Convention of the Elimination of All Forms of Discrimination Against Women, CEDAW, the Convention on All Rights of the Child, and the Convention Against the Torture and other forms of cruel, human, degrading treatment and punishment. Both states, Palestine and the occupying force, are parties to these treaties. Established norms of general international law applicable to the proceedings. As stated by the International Law Commission, norms of general international law, jus cogens, embody three essential characters. One, they protect the value of fundamental to the international legal order shared by the international community as a whole. The second, they are universally applicable by virtue of their non-derogability, since states cannot derogate from them by creating their own special rules that conflict with them. They are superior on other norms of international law, entailing obligation of an erga omnes character. The court itself has recognized the erga omnes character of such obligation. These are the norms. First, the inadmissibility of the territorial acquisition by threat or by use of the force. The prohibition against the threat or use of the force against the territorial integrity or political independence of another state is enshrined in the Article 2, Paragraph 4 of the United Nations Charter and is an essential cornerstone of the international legal order. The article, I quote, the Article 2.4 provide that all members shall refrain in their international relation from the threat or use of force against the international integrity or political independence of any state, or in any other manner in consist with the purpose of the United Nations. In case of the armed activity on the territory of the Congo, the court stated that the prohibition of the use of force is a cornerstone of the United Nations Charter. Then we go to the second paragraph, which is the prohibition against racial discrimination and apartheid. The prohibition of racial discrimination and apartheid is reflected most in CERD, as the court has very recently underlined that 182 states are parties in the CERD, a fact which confirms that universal character of the convention. Those parties include both of state of Palestine and the occupying force. It is well established that the prohibition of the racial discrimination forms part of customary law and has long been recognized as premonitory norm. The court The court in Barcelona Traction considered the prohibition of the racial discrimination to be a norm of erga omnes character, stating that such obligations derive from, example, contemporary international law, from the outlawing of acts, aggression, and genocide, as also from the principle and rules of concerning the basic rights of the human person, including protection from slavery and racial discrimination. Third, the obligation to respect the right of the self-determination. The right of self-determination exists in customary international law and recognized by the United Nations Charter, as well as in the ICCPR and ICESCR. It must be also stated that the obligation to respect the people's right of self-determination is premonitory principle of the general international law. As the court noted in the East Timor case, that right in self-determination is one of the essential principles of contemporary international law, enjoying an erga omnes character. The United Nations General Assembly has repeatedly confirmed the right of Palestinian people to self-determination. For example, the resolution 2672 of the 8th December 1970. It recognized that the people of Palestine are entitled to equal rights and to self-determination in accordance with the Charter of the United Nations, and that full respect for the inalienable rights of the people of Palestine is an indispensable element on the establishment of a just and lasting peace in the Middle East. Mr. President, members of the court, now we come to the illegality of the Israeli occupation of the Palestinian territory. The Israeli 6 decades occupation of Palestinian territory is a continuing gross and systematic breach of its legal obligation under the United Nations Charter and the general international law, also international humanitarian law, international human rights law, and customary international law, including the violation of at least 3 premonitory norms of general international law, of jus cogens and erga omnes charter. It shows that Israel has annexed and plans to continue to annex Jerusalem, Al-Quds, and the rest of the West Bank, that has composed systematic and comprehensive racial discrimination tantamount to apartheid against the Palestinian people, based on their race, and that it has denied their right to self-determination in their own land. In view of these policies and practices, Israel's occupation of the OPT is unlawful, rendering Israel's continued presence in the OPT and internationally wrongful act as seriously breaches the last 3 premonitory norms of the general international law. Derogation from which is not permitted. Israel's occupation of the Palestinian territory seriously breaches premonitory norms of the general international law, and the occupation of the OPT seriously breaches the at least 3 premonitory norms of general international law, derogation from which is not permitted. On the matter of self-determination, the occupying power has not only denied, Israel has not only denied the right of the Palestinian people to self-determination, but actively tried to suppress and to extinguish it even after the court's ruling in 2004. That Israel has under obligation, erga omnes, to respect the right of the Palestinian people to self-determination. Israel has, in fact, escalated the policies and practices with the specific intention of permanently precluding the exercise of the right of Palestinian people, including their right to independence and in their state. It is very apparent and evident that the General Assembly considered the Israeli military occupation as illegal, and Security Council the overriding necessity to the prolonged occupation when the occupation was in its early years. There is no doubt that it is unlawful is even more apparent of the flagrant now that has come to the 6 decades. As consequences of Israeli prolonged 6-decade occupation of the OPT is a clear violation of pre-military norms of the general international law, derogation from which is not permitted. The occupation itself must be regarded as illegal with all relevant legal consequences that attach under the law and international responsibility. This means that it must be brought to an immediate and unconditional end and total end. Mr. President, distinguished justice, what we mentioned is also means that the Palestinian people has the right to resist the occupation by all means, and it is a moral and legal obligation upon all states to assist and support the Palestinians in their legitimate struggle for liberty and independence. Now, Mr. President, members of the court, come to the consequences. We start by legal consequences on the occupying power. It must fulfill the occupying power, or Israel must fulfill its obligation to respect the Palestinian people's right to self-determination. Israel must immediately end the violation of the international obligation to respect the right of the Palestinian people to self-determination by ceasing all acts and measures that prevent and impede the Palestinian people from exercising their right to self-determination, including the immediate cessation of the occupation in all its manifestations. The obligation of the state responsible for an act contrary to the international law in general and international law. Accordingly, Israel is obligated to immediately cease of violation of the legal obligation in Jerusalem and the occupied Palestinian territories as whole. The cessation of this violation includes, inter alia, the dismantling of the illegal structure, including the settlements and the wall. Israel shall be obligated to make restitution and compensation for the damage suffered by the Palestinian people, and Israel obligated to immediately repeal all these laws that aims to racial segregation and discrimination enshrining in the apartheid regime imposed against the Palestinian people. The other consequences, the legal consequences for the third parties or for the third states. Given the orga omnis nature of the right to self-determination in accordance with the standing resolution of the United Nations General Assembly, it is also incumbent on all states to ensure that any impediment to the exercise of the right of self-determination by the Palestinian people is brought to an immediate end. In view of the nature and importance of the rights and obligation involved, all states have an obligation not to recognize the illegal situation resulting from Israeli violation in the occupied Palestinian territories, including Jerusalem. They are also obliged not to provide aid or assistance in maintaining the situation created by these illegal acts. Furthermore, the states parties to the Fourth Geneva Convention are obliged to ensure that Israel complies with the international humanitarian law as enshrined in that convention, including the forcible transfer of Palestinians and the transfer of Israeli citizens in the occupied Palestinian territory. Also, there is legal consequences on the UN and all the United Nations. The United Nations, and in particular General Assembly and the Security Council, should consider what further measures are necessary to remove without delay any obstacle of the realization of the Palestinian people's right to self-determination, and to take necessary measures to ensure the implementation of its relevant resolution without further delay. Then also the United Nations should consider that further action is required to bring illegal occupation, ensure the implementation of the relevant resolution without further delay. Mr. President, distinguished judges, lately we have the Libyan state submission. I will, with your permission, I will give the floor to my colleague, Dr. Nasser Al-Ghita.
I thank Professor Al-Gihani, and I'll give the floor to Mr. Nasser Al-Ghita. You have the floor, sir.
Mr. President, members of the court, it is my honor to appear before you today on behalf of the state of Libya. And with your permission, I will proceed to the final points of our presentation today, which is the submissions to the court. We submit to the court that the court has jurisdiction to deliver the advisory opinion requested by the General Assembly, as there are no grounds for declining to exercise its jurisdiction. We believe that Israel is responsible for serious breaches of obligations arising under peremptory norms of international law, including but not limited to the illegality of the admissibility of the acquisition of territories through the use of force, and the prohibition of aggression, the prohibition against racial discrimination, and apartheid, and the right of the Palestinian people to self-determination. The occupying power is obliged to immediately, unconditionally, and completely end its occupation and withdraw from the OPT. This entails, inter alia, revoking all legislation and measures aimed at the annexation of Jerusalem and the rest of the OPT, end of aggression, the blockade on Gaza, withdrawal of all occupation forces, and dismantling of its illegal settlements and their associated regimes, to revoke all of its discriminatory legislations, measures against the Palestinian people, and to respect the unalienable rights of Palestinian people to self-determination and the Palestinian refugees to return to their home, to provide assurance and guarantees of non-repetition of the above-mentioned violations, to make full reparation for injuries caused by the policies and practices vis-à-vis the state of Palestine and the people of Palestine, as a result of the internationally wrongful act or actions. All states and international organizations, including the United Nations, are obliged not to recognize the illegal situations resulting from the international wrongful act of the occupying power, not to contribute to the violations of the right of the Palestinian people, and by not rendering aid or assistance in any way to the occupying power, to cooperate to protect the right of Palestinian people and to end the occupying power's violations of those rights, by enabling the Palestinian people to exercise their right to self-determination and by holding accountable those responsible for crimes related to the colonization of the West Bank, including East Jerusalem, the unlawful annexation of the OBT, and the blockade and the current aggression on Gaza. And more generally, the violations of the fundamental rights of the Palestinian people as a whole, including the right to self-determination and to be free from racial discrimination and apartheid, as well as the right of Palestinian people to life and liberty. I would like also to stress that our observation before the court today has no legal effect in relation to the recognition of Israel. Mr. President, members of the court, this brings our presentation today to the end, and I thank you and your member of the court for your kind attention. Thank you.
I thank the delegation of Libya for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.